Hi, y'all, and welcome to tonight's live stream. Tonight, we are going to unpack the shocking results of the survey that the defense commissioned in the Bryan Kohberger case. We're going to see exactly what Idaho residents think about Bryan Kohberger. It's one of the most fascinating hearings that I have ever heard, and I am not alone in thinking that. The judge said that. He said twice, or what he said actually was twice, he said, thank you for testifying to a witness. That was really interesting. And it is just the latest twist as the state of Idaho drags Bryan Kohberger kicking and screaming toward trial. The defense has conducted in-depth surveys in the area where the crime was committed, which is Latah County and in Moscow, Idaho. And so on November, it's really one of the most frightful crimes in recent memories. On November 13th, 2022, an unknown assailant crept into a Moscow, Idaho home and stabbed 4 college students to death in the middle of the night. The 4 were all students at the University of Idaho. And as it turns out, the man accused of murdering them was a graduate student at a nearby university. So at yesterday's hearing, we finally learned about the shocking, frankly, results of the survey that the defense team did. We're going to be diving into those tonight and talking about what they mean for Bryan Kohberger's case. So back when the crime occurred, it was instantly a media sensation. I know every one of you remembers it. A month and a half after the crime occurred, police arrested Bryan Kohberger. He was at his parents' home in Pennsylvania, and they found him in the kitchen. He was wearing latex gloves and putting trash into Ziploc bags. They arrested him. They hauled him back to Latah County, Idaho, to face charges. So he has yet to face trial, but the court has set a date now in 2025. Kohberger's lawyers want the case out of Latah County. They say Latah County is particularly biased against him. Prosecutors say it's not going to make a difference. And it's going to be expensive and really inconvenient to move everybody from Latah County down to Ada County, where Boise is and where the defendants want the case. So we're going to be going into the survey that the defense says makes it reasonable for the judge to move it. I want to say a special shout out to the first 5 in the chat tonight: Drew P. Camilla Juliana Gonzalez, Can Eileen Onu, Planetary Healer, not doing very well tonight, and Sky Goddess 87. Special welcome to the 5 of y'all and to everybody tonight. If you would, be sure to hit that like button and subscribe. We would love to have you back for more. So tonight, what we are going to be looking at is right on the cutting edge of figuring out how the Constitution can work, should work in the era of social media. We're going to be figuring that out. I want to start by looking at the 6th Amendment. Let me add that to the stage. This is something that is constitutional for us. In all criminal prosecutions, the accused shall enjoy the right to, and there are several things there, a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. So that right there tells us, first of all, if you look at it, it says the accused shall enjoy. So the focus is on the accused, nobody else. These are rights enjoyed by the accused of a crime. And it has to be an impartial jury. That's what the accused has the right to. And then thirdly, I want you to notice where it says that the trial will be an impartial jury of the state and district, wherein the crime shall have been committed. So I would argue that the fact that it is set to be in the state and the district where the crime was committed gives some rights to the state and the district to evaluate crimes committed in their district and to assign liability and responsibility. But the focus here, as you can see from that first phrase, is on the rights of the accused. This is what the accused enjoy. Is that even possible nowadays in social media? I mean, can you even have an impartial jury in social media? And specifically, is it possible for Bryan Kohberger to have an impartial jury? He's entitled to it under the Constitution. So the defense put up several witnesses who described just the torrent of media coverage that we've seen. But the witness we're going to talk about today is a man named Bryan Edelman, who did a survey of Latah County, which is where the crime occurred, Ada, where Boise is and where the defense wants the trial to be, and of 2 other smaller counties. So we now have insight into what people think about Bryan Kohberger there. In a nutshell, here's what the defense argument is. The defense argument is move the case to Ada County. It's bigger. So we have a much better shot at getting an impartial jury. Sure, a lot of people know about the case, but when you have more people, you got more shots. The prosecution says it's just as bad down there as it is here. Everybody knows about this case. This is not limited to one county. And additionally, you can do other things, Judge, to make this possible. You can do jury questionnaires. You can do voir dire, traditional things where lawyers get to ask jurors questions and things like that. You can do that. You don't have to move the trial just for it to be fair. And then the third thing that they talked about and we found out about is apparently there's going to be some kind of very important and controversial information that's going to be coming out soon. We're going to take a look at what it will be. Let me be clear. I have no idea what it will be. They didn't tell us what it's going to be, but we're going to see where we find out that the state has something like that planned. So thank you, Spence. I appreciate that. You're gifting 10 Lawyer Lee memberships. Thank you very much. All right, so let us take a look at the video. I'm going to go ahead and add it to the stage so we can look at it together.
Case recognition is very high, and it's also high in Ada County.
I think I did it at 1.25 just to move through it faster. So that's the speed. It's a little faster, but I think it's almost easier to follow.
93% there. It's almost everyone in Latah County, 98%, which is similar to what I saw in the George Floyd case, where it was 99%. And it's not just a passing familiarity with the case. It's not that they recognize it but don't know much. You can see people in Latah County reported that they followed the case somewhat or very closely. Almost 70% are closely following this case. And there's a presumption of guilt. The burden has shifted. So 67% believe Bryan Kohberger is guilty of murder, and 25% reported that he's definitely guilty. So these are strong opinions.
They are strong opinions. And before we get to that next part that I circled, think about this. 98% of people in Latah County already know about the case. That's crazy. And 93%, even if they move it to Ada County, 93% already know about the case. That is an overwhelming number for them to try to deal with. They essentially cannot possibly hope to have a jury where nobody's heard about the case. Everybody's going to have heard about the case. So the trick will be finding not people who have no idea, but people who have not prejudged the case. And that's going to be hard because 67%, he points out, believe Bryan Kohberger is guilty of murder. Wow, just wow. That's really high. But look at these next two, because this is overwhelming when you think of the difficulty in the task of trying to find an impartial jury.
And 51% reported what I call a fixed opinion, where they reported that Kohberger would have a difficult time convincing them that he's not guilty. So the burden of proof is shifted on the defendant to prove his innocence. And that's undermines due process. That's not how our system is designed to work. And also on the question of sentence, you can see that 52% believe that he should be sentenced to death.
Wow. I mean, can you even imagine when they walk through the door, they know nothing about the case, and yet the prosecution, the defense, and the judge are tasked with finding an impartial jury when 52% of the people who walk through the door already believe he's not only guilty, but should be sentenced to death. This is a really hard task. It means that the system has a real challenge in the era of social media. Things are different. That is really hard. That is just overwhelming. I mean, that's an astonishing figure. There's no evidence yet, and that's already the belief. So people have to work even harder, not only to identify impartial jurors, but then to make sure that the ones who were selected have every possible reason to give the defense an impartial and fair trial. So let's keep watching.
But when you look at case recognition and size, population size, you'll find that in Ada County, there's about 16 times more people in that county that have not prejudged, if you do the math. So yes, those numbers look the same for those who recognize the case, but there's a much larger swath of people who haven't prejudged.
And that, in a nutshell, is what the defense is going to argue. We've got more people. The prosecution has a really good argument against this that we will hear later, but that's their argument is you've got a lot more people. So if you're going to have a whole bunch of people who are biased, you can have more. You can have a better shot of finding somebody who isn't just by sheer bulk of numbers. And Michael, good luck with the big move next week. Hope that goes well.
Almost 40%, 39% personally experienced high levels of stress, anxiety, or fear during the search for the killer while they were here. So that's very high. And then 45% know someone else who has. And if you look at those together, it's actually about 63% have either personally experienced fear or know someone who has during that search. And that shows like the impact it had on them. And you'll see it later in some of the opens where people talk about, I was scared to walk outside or running to their car from work because they don't feel safe. They can see the house from their office. One person mentions that their wife was scared to go to the supermarket. People talk about they locked their doors for the first time. On the anxiety question, that number for Ada County is about 32%. So it's much lower.
So
you can see.
Let me stop it there. What the defense is arguing is you can't just look at the number of people who have heard about the case because, granted, that's pretty much everybody. Instead, what you have to look at is sort of the underlying feelings that people have about the case. And they're more intense in Latah County because that's where the crime occurred. So people were literally afraid following the murders and following all of the initial publicity about the stabbings that happened right there in their local community. But I would be curious, would you go ahead and put in the chat or in the comments if you're watching this after the fact, have you experienced fear? You're not in I'm going to assume you're probably not in Latah County. Because it's a pretty small county. But I would like to know, have you experienced fear since then? Because I have a feeling that it's not just limited to Latah County, that it's pretty universal, that people think about that and have thought about that ever since the crime occurred. So the defense went through a list of media items using another witness saying all of these, there were so many articles about it. And in this survey, they took some of the information from those articles, particular things that people might have heard about, and they asked potential jurors, have you ever heard about this? There were 9 of them, and you'll see them in just a minute.
Almost 80% of people in Latah County were familiar with at least 5 of the 9 media items we tested in the survey, almost 80%, and 52% knew 7 out of the 9, or at least 7 of those items. So they have a lot of case knowledge here. It's quite high. This is not a case where people have moved on. Almost everyone in the community recognizes this case. You're at 98% recognition rate. And it's not just a passive familiarity. People are closely following the case. 29% are following it very closely. 39% are following it somewhat closely. So you're basically at 60% closely following this case, which is quite high.
And that, I'm not at all surprised. I mean, I think people are following this and continuing to follow this across the world, but definitely across the United States and across other states other than just Idaho. I think it remains a pretty sensational, important topic for people, and they're still discussing it. So I agree with that. But these particular 9 media points, we'll get to those in just a minute, but they're really important because not all of them are true, but probably all of us have heard about them. And that's one of the things that bothers the defense the most, is that there may be fake information out there, false information. Part of the reason that people may prejudge him is because of seeing fake information. And they've seen a lot. They've seen 7 of the 9 media items they picked. So one absolutely fascinating point that they concluded was that the more you know, the more likely you are to think that Bryan Kohberger is guilty. So if you've been following this and you've been reading the articles, you are more likely to think Bryan Kohberger is guilty. Now, think about what that means, because it has a lot of different meanings. One thing is, well, okay, is it going to be hard to find people who can try the jury? Well, yes. And if people are knowledgeable, they're going to think he's guilty. And that is something in and of itself, because it suggests that when the state goes to present the case, it's going to very likely be able to persuade people, because when people have a lot of information, they tend to think he's guilty. So that means that probably when the state presents its case, it's more likely then that people are going to think he's guilty.
So whether or not people are closely following this case is significantly related to bias. So if people are following it very closely, within that group, the guilt rate is 84%, and somewhat closely, it's 73%. Just kind of looking at it combined, you're at basically 77% of people who are following it somewhat or very closely believe the defendant is guilty of murder. So the more you follow it, the more likely you're to be exposed to prejudicial content, the more likely you are to develop a complex memory and case knowledge, and more likely to happen. There's a lot of.
So I just find that absolutely fascinating, because they're saying that if you are very closely following the case, at least in this survey, 84% concluded he was guilty if they are very closely following it. Now, they got to decide what very closely following it meant, but that says something right there. That says something pretty powerful. And those are the very people that the defense has to figure out a way to get off the jury. And actually, so does the prosecution, and so does the court, if they are to give Bryan Kohberger that impartial jury that he is entitled to have constitutionally. So the next section is going to talk some about complex memory. And that was really interesting. I'm telling you, it's a fascinating hearing. All of the witnesses were interesting, but to me, this was the one I wanted to present to you first anyway. But, you know, the concept of maybe your memory, you may have a little bit of it that seems obvious. You can remember it, you can pull that up, but there may be other things underlying it that are somewhat remembered by you, but they aren't at top of mind, but they may influence how you ultimately feel and what you ultimately think. So here's what the witness said about that.
References to things that, you know, the defendant committed a murder in Oregon, like speculation, no evidence of that. It's just something they heard, that he talked about committing the perfect murder on a paper, or that he hates women and he had trouble at the university he goes to with women, and people who worked with him had problems. He stalked her because she didn't respond to him. People were looking at Reddit comments or Reddit posts he had made and from years back, all that kind of stuff. And then references to him, you know, having obsession with some of the victims, ritual animal killings. And these are just a couple examples. Like, you'll see that stuff everywhere, but the amount you see in Latah County is much higher. And
so many of those have not been proven to be true. There's been no evidence that I'm aware of ritual animal killings. And some of the initial rumors that he had stalked one of the victims proved to be not true. So some of those are false. But what they're saying is people may have heard about those. And even though that doesn't get presented at trial, that may bubble up during trial, or it may play a part in how they view it. If they heard that, they may think, oh, yeah, that's right. He is a terrible guy. I don't really remember why, but I can remember he was really awful. And they're concerned that that's the kind of thing that is going to bring the jury to a guilty verdict and to a death penalty verdict. And it's going to be underneath the surface. So that's exactly what they're worried about. And they're saying those sorts of underlying beliefs are greater in Latah County.
You see that in the other questions. So asking about if people experience stress, anxiety, or fear during that search. And you can see 39% reported that they personally did, and another 45% reported that someone they know. And if you look at those, it's called a crosstab. And the question is, did you or someone you know? It jumps up to 63%. What really stood out to me was this shattering our sense of innocence, right? This is an innocent town, and no crimes or horrible things ever happened here. And this guy took it away from us.
And that is unique, they're saying, to Latah County, a small community where people are really extra afraid, where they had this sense of safety and well-being within a community, and that was stripped away by this murder. And they have a unique concern about what happened that you don't find as soon as you move outside Latah County. And speaking of innocence, the defense also argued that these statistics show that Bryan Kohberger is not presumed innocent in many places, and one of them being Latah County.
In this case, 67% of prospective jurors who recognize the case believe Bryan Kohberger is guilty of murder, and 25% have a strong opinion on that. So if you think about it, given the high recognition rate here, if 100 jurors walked into this room during voir dire, 66% of them already think he's guilty before they've heard any evidence. And if you start looking at things like, well, do they know a lot of detail? That prejudgment jumps up to over 80%. Do they closely follow it? Jumps up to 70%, whatever. So the question I ask is basically based off, I'm going to start talking subject now. Based off of what you've read, seen, or heard, would the defendant have a difficult time convincing?
So, you could argue this a couple of different ways. You could say, well, on the one hand, the evidence that people who know a lot think he's guilty, that means that the case is really pretty strong. That means the prosecution will have an easy time of proving this case. Or you could argue the opposite way, which is people have some fake information in their heads, and that's part of the reason that they reach this conclusion. So you could argue it either way, and the prosecution and the defense, not surprisingly, take opposite opinions.
You that he's not guilty. So burden of proof shifting on the defendant. I think I mentioned this last time, but that question was developed by a judge in Tennessee. And what you were seeing was they would ask jurors, well, what do you know about the case? And they would tell them some information or minimize what they know. And then the question was, do you think he's guilty? And maybe they'd say yes. And then they'd say, but I can be fair and impartial. I can set it aside. I think I can do it. And then the follow-up was, well, would he have a difficult time convincing that he's not guilty? And oh yeah, I can't change my mind. So it's just much more effective. I find it's more likely to be correlated with these other indicators of bias. So it seems to be more of a valid question. And when I did it, you see basically 51% indicated a strong opinion that would shift the burden of proof onto the defendant. And again, if you look at our analysis of 100 jurors walking in, that would be 50 out of 100 would fall into that category.
They can't change their mind.
Well, I'm sure you can get them to say they can be fair because I see it all the time. But this doesn't mean they can't.
Did you ask?
So that's fascinating, because what they're saying is we actually talked to people, and we've done studies where we ask people whether they can be fair. That's been long considered sort of the magic question for lawyers, for judges, when they want to rehabilitate a juror, because a juror will come in and say, well, I kind of am leaning toward one way or the other. And the judge will lean forward and in the robe say, but do you believe you can be fair? And the juror will say, oh, why, yes, of course. Yes, absolutely. And can you put aside any bias and pay attention to only what's said in court? Oh, absolutely. I could do that. And what this is saying is, what I think probably most people would suspect anyway, that's sort of coerced, that in an environment where you're supposed to be fair, you may say that and it may mean absolutely nothing. If 51% of people have already said it would be very hard for me to change my mind, or I don't even think I could change my mind, then what that means is you've essentially shifted the burden of proof. The burden of proof is now on the defendant to prove innocence, because 51% of people are already sitting there thinking, I'm not buying it. I think you did it. And they are already waiting for proof that the person didn't do it, the opposite of what they should be doing. That's really important information. It has a lot of impact, frankly, for the legal system, a lot of impact for jury selection. This was absolutely fascinating testimony, because it is very different from what lawyers and judges typically think, and definitely from how they act. Now, there are even prejudgments, according to what the survey said, about whether he should get the death penalty.
A fixed question about the penalty.
Yeah, so I asked the same fixed opinion question, and you find that 51% believe that the sentence should be death and that he couldn't convince them that it should be life. Only 19% reported that the defendant would not have a difficult time convincing them that he should get a life sentence.
So taking that and all of the bias that the defense says is within Latah County, they talked about one thing in particular, which is the unique pressure within the community, because these people, after they leave court, have to go back out into the community. So if they've looked at the evidence and they have said, we do not believe Bryan Kohberger was guilty, or we don't believe he should get the death penalty, they then have to go out and say hello to the next door neighbor who was on the law enforcement team that captured him. They have to go out the next day and talk to their neighbor who teaches at the university. And so the idea is there's a lot more involved for them than for people in other counties.
One of the things I wanted to look at, because it's a small community, my guess is people can figure out who's on the jury by who's not picking their kids up at school and talking to neighbors and all that. is there pressure? Do the jurors ever feel pressure like there has to be a certain outcome? How would the community react if he's not convicted, if he's found not guilty? And there was quite a bit of strong comments on a range of themes from people would basically kill him, to they burn the courthouse down, or assume that the jury failed, or that he would have to prove that he was not guilty. Again, shifting the burden. Other people talked about the fear if he didn't do it. Well, who did? Like that means this person's still among us, who creates the same stress and fear and anxiety that people had before. So this community needs closure, and you have to imagine what that's like for a jury from months on end, in and out of this courtroom in this tiny community, and trying to explain to their neighbors, what they did and why.
Were the other counties as high of rate in these kinds of answers? Did they have a similar kind of answer as Latah County potential jurors did?
No. Now,
So now you are going to get to hear those 9 media items that I told you about. They're going to talk about the media items, how many people knew about them, and then go into what they were. What are the things, the 9 pieces of information that they thought sort of gave an indicator of whether or not you've closely followed the information, including some of the stuff that came out, at least initially, that was
in
followed.
Latah County, you can see that 79% were familiar with at least 5 of the 9 media items, and 52% knew 7 or more of the media items that we tested, over half.
And you tested on 9, is that right? 9.
Yeah, tonight. So the more people know, the more case knowledge, the stronger their opinions, the more likely they are to develop a perception of guilt. So people who were familiar with 5 or 6 items, you can see it's 66% guilt rate, and for 7, it's 82%. So jumps up quite a bit. So the more case knowledge you have, the more likely you are to believe guilty. And you see the same thing with that, I call that fixed opinion question. That's significantly related to case knowledge as well. So the number of people who said that he would have a difficult time changing their mind is essentially 66%. If they know 7 or more items.
Let's talk about the specific items that were known, just a few of them. We won't go through all of them. What did you learn?
So these are just going through a few that we tested, and you can see high recognition rates and significantly related to prejudgment. So whether or not people know that a knife sheath was found on the bed next to one of the victims, 81% of survey respondents in Latah County knew that detail. And you can see it's significantly related to bias. So if you knew that, 72% of people who knew that item believe he's guilty, and 55% reported that he.
But remember, what he's saying is, if you knew that they found a knife sheath with DNA, you're more likely to believe that he's guilty. But of course, that's the key evidence, right?
A difficult time convincing them otherwise. So the next one is whether or not they knew that DNA was found on the knife sheath, that there was a match for the defendant. And you can see that 67% know that detail. And if you know it, it's highly prejudicial. So 75% of people who know that item believe that he's guilty, and 60% reported a fixed opinion.
How about a vehicle recording?
So this one, whether or not Bryan Kohberger owns the same type of car recorded on the video driving in the neighborhood where the killings occurred. This was a widely reported media item. So 86% of people know that detail, and 82% of those who do know that believe he's guilty. Quite high.
So all of those things, and we are things that are true. Now we move into some things that are either not fully explained to the public yet, or even false.
How about the cell phone tower media item?
So on that one, you see a case recognition rate or item recognition rate of 79%. 79% of survey respondents knew that detail. And if you knew that, 72% of them believe that the defendant's guilty.
How about the media item studies?
So this would go down to like a misinformation, I'll call it an inaccurate detail that was widely reported, that the defendant had stalked one of the victims. And you can see recognition rate currently at 45% when the survey was done. And 81% of people who knew that detail reported that guilty.
How about following on social media?
I believe this is the last one. You can see whether or not he was essentially following them on social media, 45% recognition rate, and 79% of those who know that believe he's guilty. And these are all statistically significant findings. And you can see that in terms of how closely they followed it is less than we saw in Latah County. So Ada is 58, Canyon is 51, and Bannock is 46. Compared to Latah County, remember, it was 68%, much higher.
For those items, I had heard all of those items, every last one of them, except that I had heard that the he followed them on social media. I had heard that that was false, that that was incorrect. I remember initially hearing that, but if they had asked me, I would have said, I think that's false, or I heard that was false. So that would have been my response to that. And the stalking as well. What I had heard was they didn't have any evidence of that, that in fact wasn't proven when they finally got into the details of the case. So there were, one of the things the defense used to persuade the judge was they argued that Latah's very different when it comes to things like the fear, like things about talking about the case with other neighbors, and that's going to make a difference.
So remember we said that 79% of people in Ada County had talked about this case. Might be wrong, might have been higher. It's just 60% in Ada County, 50% in Canyon, and 51% in Panic. So it's much lower. You'll see whether or not they've experienced high levels of stress. In Ada County, it's just 17%, and the other two counties, it's only 11%. It was 39%. We had, I think it was 79% in Latah County, knew at least 5 of those media items, and it drops to 65% in Ada, 52% in Canyon, 59% in Panic. If they do 7 or more, that was 52% in Latah County. It's just 42% in Ada, 27% in Canyon, and 29% in Panic. So less case knowledge. And we know case knowledge comes back to belief perseverance, right?
So I'm curious, how many of the items did you know that were listed? All, some, 4 or 5? Like, where would you be on that list? Go ahead and put that in the chat or the comments. I'm curious where y'all stand. I'm going to head down there and see as y'all put that in. So the defense argued, look, people in Latah County are more likely to either have gone to the house to look at it or just to pass by it in the course of a regular day. They are more likely to know somebody in law enforcement in Latah County, right? And they add that it may be set up so that the judge can ask each person if they're going to be fair, but there's just pressure from the community for them to say yes.
It's very easy to rehabilitate a juror to get them to say they can be fair. It happens all the time. So a juror says that I had this experience, or I think I'm leaning towards one side, and it's so easy. We do it all the time to get a socially desirable response. You start with, well, the law requires everyone to be fair. Everybody has their own opinions, and that's okay. We're just asking you, can you follow the law? Can you follow the instructions? Can you deliberate? Can you be fair? And most people will say yes to that because they want to create a socially desirable response. They know what the right answer is. No, there's no data to suggest that this is a valid question. And just touching on the research again, what you would expect is people that know a lot about the case or been exposed to prejudicial pretrial publicity would be more likely to say they cannot be fair and impartial compared to people that do not know a lot about the case. And it's not, there's no significant relationship. People who know a lot of detail and have been exposed to prejudicial pretrial publicity are just as likely to say they can be fair and impartial as people who have not.
So remember, though, what we're talking about is people who have prejudged because they have some information. So that is an important difference. Now, the next thing they talked about was stealth jurors. I did think this was, I'll give you my opinion at the end. Go ahead and hear this and then I'll talk.
This is an example of a stealth juror. So a case like this, you're a stealth juror, stealth. There's a likelihood that people want to be on this case, right? It's a high profile case. It's going to be on TV. It's going to get a lot of attention. There might be a desire to seek justice and you want to be involved in that. So
I personally didn't think this particular argument was all that persuasive because I think that could be true no matter where you live. I don't think that was specific to Latah County. Someone who wants to write a book or be interviewed by the media or just have posts they can put out, that could be anybody. It doesn't matter. It doesn't necessarily have to be unique to the county where the crime occurred. So, but I understand their point. It is always a worry for people in big cases like this that lawyers will get on there wanting to make their mark, did I say lawyers? Jurors will get on there wanting to make their mark, wanting to say something about what happened, wanting to have their say in it. So I am looking through and I see that y'all knew lots of those points. I see ranging from 2 to all to 7 to 5 to most, a few. So all sorts of ranges, which is pretty much what they found also within the county. All right, so people, the defense argued, under-remember. Then they get their memory jogged, after which it may be too late. It kind of mixes in with the evidence that's come in at trial. They may not be able to distinguish between those little things that they've heard in order to make a decision on just what is allowed in at trial.
The common example is tell me everything you know about a movie. I'm going to go with Star Wars. And you probably will tell me a lot because a lot of people have seen that movie or seen it a bunch of times. But if I asked you follow-up closed-ended questions, you'd find that you forgot to mention a whole bunch of things. Like maybe you didn't mention that Luke Skywalker was Darth Vader's or son, right? And it was, do you remember that? Oh, of course I know that. I just forgot to mention it. So you see things like that. So the tricky thing is you can't ask people, have you read, seen, or heard if the defendant was stalking one of the victims? Because now you're poisoning the well. What if they didn't mention that and they're open-ended? Doesn't mean they don't know it, because we know about 45% of the population here does know it. So you're in that position where you are trying to make an assessment if this juror can truly be fair and impartial without knowing what this juror actually knows about the case. And that's one of the biggest problems you have in high-profile cases that are not a problem in your run-of-the-mill typical case.
I thought that was a really good illustration, because that certainly is true, that there are memories that you wouldn't describe. If someone said, tell me about the Bryan Kohberger case, you might say, well, 4 college students were killed. It was the middle of the night, and he was arrested at his parents' house. They'd say, well, was a knife sheath found? Why, yes, there was a knife sheath found, and it had DNA. But you might not have mentioned that in the first. Everything you said was something you knew about the case, but you didn't just mention everything you'd ever heard about it, because that isn't kind of the way our brains work. We just bring up little bits. So they taught then about a final finding in the survey.
And what we found in this case was that 96% of survey respondents knew at least one of these media items that they failed to mention in the open, and on average, they recognized an additional 4.9 media items.
Which means that based on what I'm seeing, y'all are at least average for Latah County, and you don't even live in Latah County. So good for you, you're informed.
So this is the one we talked about, whether or not the defendant stalked one of the victims. Prejudicial, 45% of survey respondents recognize this item when we asked, have you read, seen, or heard it? But when we asked them the open-ended question, what have you read, seen, or heard about this case? Only 3% mentioned it on their own. So 3% of people reported this item, but 45% actually recognize it later on. And we know it's not only is it not true, but it's also prejudicial, because 81% of people that know it have already judged the defendant as guilty. So it's really important to know who are the people in this panel that know that detail. So your choice is to just assume no one knows it because they didn't spontaneously mention it, or poison the well by asking the juror specifically, did you know that Bryan Kohberger allegedly stalked the victim? So that's a difficult position to be in.
So that does assume, though, that the reason that the person concluded that Bryan Kohberger was guilty was because of the false information of the stalking. And it could be for a host of other reasons, but they're saying the fact that this person knew more and knew this fact, and there's a bigger response rate for guilty in this group, means that what we can kind of figure is the people who are hearing this, the people who are hearing about the stalking, those people are very likely to conclude that he's guilty, and they must be factoring that in. So the defense is kind of assuming that it gets factored in. And they found the exact same problem with the knife sheath, although, as I understand it, that part is true.
Let's look at one more example of how that worked.
So this is the one about the knife sheath, whether or not police found a knife sheath on the bed. So you probably want to know that. Well, 81% of people recognize that item later, but only 8% mentioned it when asked the open-ended question. So again, just demonstrating the problem. These are items that are correlated with bias. We know that there's a high rate of recognition in the community, but when you ask in jury selection, what have you read, seen, or heard about the case? Very few people mention it.
And I do think that that's probably just a factor of there are a lot of different details to tell somebody about. So if you give a narrative, you don't necessarily throw out every detail you ever knew about it. That wouldn't be kind of the normal way that people would respond. They also gave a really interesting example from another case about a social media post where someone made really dramatic posts about a case, saying that they were overjoyed by the defendant's arrest, that they were physically ill at what the defendant had done, and that the defendant was a sociopath, and then said, listen.
And he gave open-ended responses as to why. So this is our participant who mentioned that they were overjoyed by his arrest and they were physically ill, and that Robert Just was a sociopath. Well, they, on a scale of yes, definitely to no, definitely not, they reported that they could definitely be fair and impartial. And they reported that I could start from the beginning and listen to all the information presented and follow the directions and wipe out everything that I know. I would need to be convinced beyond a shadow of a doubt. So that answer, if you see in a courtroom without knowing that this person was making public statements about the defendant being a sociopath, probably considered rehabilitated.
Your Honor has to.
So if you compare what the defense is going to say to what the prosecution is going to say here, the defense is saying somebody who has already written on social media that the defendant is a sociopath, that's not someone who can be fair and impartial no matter what they tell you. It's just false. They've already concluded the person is a sociopath, and they've already concluded that they were overjoyed when the person was arrested. This is not a fair person. This is not an impartial person. But at the same time, the prosecution is going to say, look, you can find those people in any county, and you can get rid of them by asking questions such as, have you ever posted on social media about this case? And then maybe they would say you could go and look it up. I don't know what the prosecution would argue from there, but they're going to say this is not something that is limited to people from Latah County. You can post when you are not from Latah County. So this isn't going to change by moving it. It may be something that shows bias, but it's not something we can fix with the move to Latah County. So the closing arguments were really well done. I thought I would just give you a quick snippet, like the paragraph from each. I'm going to start with the defense, and then because they went first.
To look at the content and know the content of the media and know that there hasn't been positive stories about Bryan Kohberger. It's negative stories. There's not a media story talking about Bryan Kohberger's right to be presumed innocent. There's not a media story talking about Bryan Kohberger being loved by his family. Nobody's talking about the good grades he achieved all through his undergraduate career and graduate programs. Nobody's talking about the dog that he loves and helped train. It's all negative. It's false. It's misleading. It's stuff that's rumor and never coming into court. There are things about his character that are just untrue that are out there.
While that's true, I think the defense has done a pretty good job of getting out there that the stalking and the social media following, those were not true. That they've said that in hearing after hearing. We've heard that, it's been reported. And for much of the rest of the 9 points, there is evidence of that the state is going to produce. I assume the defense will have some responses to that, but there is evidence that he drove a white Hyundai Elantra. There is evidence that a knife sheath was found at the scene and had his DNA on it. So we're going to hear all of that at trial, but it's already been presented to the court in the form of their affidavits and so forth early on in the indictment process. So to me, I thought one of the most compelling defense arguments had to do with the local jurors and the pressure they were going to feel. And here's how she summed it up.
And those jurors that sit over there are going to feel an immense amount of pressure to answer the call of the community to be safe. You can read those comments about what people in this community think about Mr. Kohberger and what they think would happen if the jury found him innocent. It's hard to imagine that one of those jurors who all of a sudden said, you know what? I'm not sure, and listened to more evidence and said, I'm really not sure. I don't think he did it. Are they going to be brave enough to do that, to write not guilty, to say not guilty, and to stand their ground? In Latah County, we don't have it. We don't have it. Canyon County, we also don't have that. Those are jurors that are not from this small, close-knit community. Those are jurors who aren't going to run into police officer that investigated the case at the grocery store, or maybe somebody from the prosecutor's office at the jazz festival at the college. There are people who don't have those connections.
We're not asking the court at this point to seal all hearings going forward.
Let me stop it for a minute, and I want to talk about that. Allison, you made me smile. You made me laugh with you got to move it. That is actually my opinion too, but we'll get to that in just a minute. So this is now the prosecution you're going to hear. And this is where the prosecution gave us a hint that there's going to be something more coming out. And the prosecution wants to seal that hearing so we don't get to hear it. So the part that I just played said, we're not asking the court at this point to seal all hearings going forward. Somewhere in that phrase is where I stopped it.
But the state believes that there may be certain evidentiary hearings. For example, if the state files 404B notices or motions in limine related to the evidence, some of that information might be extremely prejudicial, and the state would agree to seal hearings where prejudicial information is going to come out in that hearing. And that too is a tool that the court has before it to alleviate some of those peaks in media coverage. If this court were to summon.
So, but that is actually something that they've wanted anyway. They've wanted this sealed, and it's like, oh, well, conveniently, this fits right into our argument that here's a way that the court can monitor this and prevent there from being a leak of this that would prejudice the potential jury pool. I think those are two separate issues. I think the public access to the information is separate, but that's an argument that they're making. You can tell from this, though, they say information is going to come out in that hearing. And they said it might be extremely prejudicial and the state would agree to seal it. So I'm very curious. I have no idea what that would be, but it certainly sounds interesting. Now, the second point that the prosecution is going to make is this is not really going to make a difference. This is a great argument. I'll just play it. It's a really good argument.
A jury of 1,800 jurors, which was the amount that was summoned in Ada County in Dale. This court could just as easily summons 1,800 jurors in Latah County with a prospective jury pool of 32,000 as a court could summons 1,800 people in Ada County. It doesn't matter that Ada County's population is 16 times higher than the population in Latah County, because in Ada County, the court, if the court moves this trial to Ada County, is not going to say, well, we're in Ada County, I guess I'll summons in 20,000 jurors. That's not how it works.
And that's a good point. You call in a pool of jurors, and they come in, it's a certain number. And if 93% over here have already heard about the case and 98% over here have already heard about the case, those numbers aren't hugely different. They aren't wildly different. And so what does it really matter? You're going to call in 1,800 people no matter where you are. And your percents are not going to apply to everybody in the county. They're going to apply to how many people came in and are sitting right there in the jury pool for you to pick from. The third argument that they make is that they're going to be enough to pick from. Here's how they argued it, and then I'm going to give you a thought on it.
10% of Latah County jurors had no opinion on total prejudgment. That sounds low, but when you look at it out of a jury pool of 1,800, that's over 300 people walking into this courthouse with no opinion about the case.
The problem with that is that's not the only issue. The only issue isn't people who already have an opinion about the case. I mean, that's a huge issue. But you've also got the person who is married to the law enforcement officer who was on the case. You've got somebody who teaches at the university. You've got people who have other reasons that might bias them or that might give them a reason to rule in a certain direction. Or maybe they're just busy. Maybe they can't do jury duty. So the fact that 300 people, I mean, that's a pretty small group to start with. I did think that was a problem for the court. If thought about, correctly, I think that's going to shrink. Every time you ask another question, you peel off another set of jurors, and it could get pretty small.
You can't just say, well, it's bad in Ada County too, so I won't change venue here. The question for the court is, in the county in which Mr. Kohberger is charged, can you seat a fair and impartial jury? And that answer is no, you cannot.
So I didn't exactly agree with the argument that the defense was making there. Right there, they're arguing, just focus on Latah County. If you believe it can't be a fair trial, then you have to move it. Don't focus on whether Ada would be any better. Focus on Latah. But I don't really think that's a fair way to look at it, because the judge has to make a decision of somewhere else to move it. Otherwise, what might happen is the court might say, well, I just don't think he can get a fair trial anywhere, so I'm just going to set him free. We can't possibly try him without violating his constitutional rights. And I think that would be I don't think that would be the right decision either. And here, I wanted to play this little bit from what the judge said at the end. He really is having a hard time.
I would say this is probably professionally the most difficult decision I've ever had to make. Both sides, have made really solid positions and supported that.
You can see case recognition.
So I'm going to pull that out and go ahead if you have some questions. Put question marks at the beginning, and I'll go through and answer some questions. And Allison, so glad you've been a member for 3 months too. I wanted to say that. The judge said that this was probably the most difficult decision he'd ever made professionally. I was kind of surprised by that. I wouldn't have thought it would be that hard. He clearly thinks it's right down the middle. He doesn't really know which way to rule on this. For me, I would easily move it. I don't even think there's a question. And the reason I would easily move it is because I know that death penalty cases are extremely hard to hold on appeal. So you want to give every possible benefit of the doubt to the defendant. You want to give everything you can to the defendant, and because you know that on appeal, it's going to be hard to hold anyway. So you want to take off any issue you possibly can, remove any problems that you might have, make it as fair as you possibly can. And not just for keeping it on appeal, but also because that's the right thing to do. When someone's life is on the line, there is a constitutional right to an impartial jury. And if there's a question about whether you can get that, I think it's a good idea to go ahead and make arrangements to find a place where you can get the impartial jury. Now, Ada County may not be that place, but it needs to be somewhere in Idaho by the Constitution and because of the fact that it was a crime committed there. But it's really an interesting issue because of the fact that this is something that is more and more an issue because of social media and because cases aren't local anymore like they used to be. It used to be if there was the local newspaper covered it, maybe everybody read it, but you could move one county over and they'd never heard of it. They didn't read the same paper. They got a different paper. That's not the way life is anymore with social media. We have a lot more information. Okay, Afton asking me, can they bus in a jury? Is that a good option in this case? That is actually one of the things that the prosecution talked about was bringing in a jury from a neighboring county and saying, yeah, that would be inconvenient for that jury, but ultimately it's only going to be down to maybe 18 people, 12 jurors, 6 alternates, some smaller number. And that's a lot better than all the inconvenience of trucking everybody, all the witnesses, law enforcement, everybody down to a different jurisdiction. I think one of the things that they have working against them, the prosecution, is the fact that a judge has just done that for Lori Vallow Daybell and Chad Daybell, and it worked out fine, and the end of the world didn't come. So I think that does make it more likely, sort of weigh on the side of the judge deciding to move the case. Loretta asking me, can you discuss the difference between facts, truth, proof, and evidence? So, it's not like those are technical terms, really. I mean, evidence would be things that are actually submitted as proof to the court, and to the court could be in a hearing, could be at trial, it'd be different things. So that would be evidence, and your proof is the evidence that you bring. So those are kind of the same thing. So facts might come not just from evidence, it might come in the form of testimony at a trial from a witness, and who might say, yes, the following things happened to me. And so those are all kind of terms that get used, and they flow one into the other. I don't think there are clear distinctions between what each of those terms means. All right, looking for question marks at the beginning. Here's Xana asking, is there ever a time when there's a change of venue for a case like this and a stipend is given to the victim's family for lodging, since this would be too far to commute daily? I can't answer that question, Xana. That's an interesting question. I don't know that I've ever heard of that happening. It would really depend on whether there was a fund for that. For example, sometimes a county will have a victims fund, and maybe they could use that to pay for that. The only thing is it's probably not going to be available for other victims. It would have to be increased to deal with this particular case. Nonetheless, somebody may suggest that or may propose that. I know that at least one of the victims' families had wanted it to stay in Latah County because they lived north of the county. And the county where this would be moved to is south of Latah and a good distance from them. So they were really wanting it to be more local. All right. Well, I am hoping to drop a video this weekend. Watch for that. Hopefully I will be able to do that for sure. I will see you on Monday at 7 p.m. Eastern, and I look forward to that. I will see you soon.